Hi, good afternoon. It's Tracy B from the Divorce Solutionist. This is Thick of It Thursday, where I go live and I discuss some family law related topic, issue, hypothetical, real life scenario. Sometimes I'll discuss a high profile divorce or custody battle. I haven't found anything really juicy lately. Um, that would be tea worthy. So I'm going to resume the client's rights and responsibilities I started a couple of weeks ago. And I'm going to continue going through, if I can find it. And I still have a bookmark it, but what I did, I am using a different phone again. And so um, I bookmarked it, but I bookmarked it in the different in the other phone. Go figure. Anyway, I thought it was important to go through clients' rights and responsibilities, particularly in family law matters, because family law cases are very, very volatile. They're very emotionally charged. They can be financially draining. They could be mentally exhaustive, and they could actually take a toll on you physically. As far as your health is concerned. But because of all the ethical reasons, ethical issues that come up between the lawyers and the clients in family law, um, each state has their own model of clients' rights and responsibilities, which is modeled after the American Bar Association, um, um, their framework. They have a list, and each state adopted its own version, but it's based off of what the American Bar Association, which is the umbrella bar association for all the states, all the lawyers in every state. Each state has their own, but what most states do is they use the ABA as the as a guideline when they come up with their own, you know, everything that's relegated, that's important or help them to regulate lawyers. So anyway, excuse me. Anyway, so I started on that because, as I mentioned for the past couple of weeks, um, one of the major complaints that clients have about lawyers in family law matters is that they don't communicate. They don't answer their emails, texts, phone calls. They don't fill them in on what's going on in their case. And they charge them up the wazoo, and they don't get the outcome that they thought they would, that the lawyer either promised them or assured them they would get, or they just were never specifically told what the possible outcome would be, and they feel shafted. So, and I think I mentioned several times, because I always do, how important it is to, when you're signing a retainer agreement, and every one of you should sign a retainer agreement, whether it's a pro bono lawyer or not. You should sign some agreement with the lawyer who's representing you on your case. And what I'm talking about is lawyers who are taking on your whole case. Now, what some lawyers are doing is they're offering limited services where they may just draft a motion for you, or they may just write, discovery for you. They may just do part of your case. In that particular instance, you may have a different sort of agreement with them, and it still should be in writing, actually specifying that they're only representing you for that limited scope. But when it comes to a lawyer who has full representation for you in your case, you should definitely have a full agreement, and you should understand exactly what's in the agreement. And in addition to that agreement should be a statement that says client's rights and responsibilities, or some language to that effect. But it should basically, in addition to the agreement, you should get something that spells out exactly what your rights are as a client and what your responsibilities are as a client, what your responsibilities are to the lawyer, because the relationship is dual. It goes both ways. Just like you have rights when you're a client, you have responsibilities to the lawyer, because the lawyer has, they have to answer to the Bar Association, the ethics committee, whomever, the judge, whomever. So you have rights and you have responsibilities, and it's important that you know that from the onset. Don't sign a retainer agreement rushing and not getting an idea of what you are entitled to, how you should expect to be treated, how you should be communicated with, how you should be billed, all those things. And when you get that, make sure the lawyer spends time going over provisions in the agreement and the client's rights and responsibilities that you don't understand, because you have to sign it. And once you sign it, you're bound to it. It's a contract, it's an agreement. So you should definitely understand what you're signing. Because way too often I hear people complain about they didn't get an agreement, or they got when they signed it, they didn't read it, or the lawyer didn't take time to explain it to them. No, you shouldn't sign it then. You should take your time and ask the lawyer to take their time to explain to you what's in the agreement. Okay, so last week I started in on the client's responsibilities. The week before I went through the client's rights. Last week I got through the client's responsibilities, which is the responsibilities you have to your lawyer, so that your lawyer can provide the most effective, professional, efficient representation of you in your case. And I think I got to, I don't know where I got to, so I'm going to start at 1. The client is expected to treat the lawyer and the lawyer's staff with courtesy and consideration. That's a no-brainer. And I'm using one state's example of client's responsibilities, but they all pretty much cover some of the same main objectives. And that is the way you should communicate with and treat your lawyer, the way you should be truthful with your lawyer, the way you should participate in your case, and the way you should provide information in a timely manner. And, there's some basic things that they all cover, but I'm going through New York specifically. The client's relationship with the lawyer should be one of complete candor, and the client should apprise the lawyer of all facts or circumstances of the matter that the lawyer is handling, even if the client believes that those facts may be detrimental to the client's case. And I get this a lot. I got this a lot when I was in private practice, that clients would keep some details out, some major details, they would leave them out, and when I would find out, and I hated this, I would find out when we're in court, and my adversary, the lawyer for the other party, would bring it up to the judge. And then the judge would look at me, expecting an explanation. And I'm looking at, like a deer, caught with the headlights shining on. I'm like, and I would, later I would chastise my client and say, why did you let me get blindsided like that? Why didn't you tell me A, B, or C? Oh, because I didn't think it was important, or I didn't want to tell you because I didn't want to get in trouble, or I didn't think that, whatever. And I'm like, I've always made it clear to clients, or potential clients, that you have to tell me and let me decide. I don't like being blindsided. Of course, I'm always quick-witted, so I would come up with something really quick to appease the judge at the time. But, I would never throw my client under the bus. Well, it depends. If it got to the point where the judge wants to punish me or penalize me, then yeah, I'm sorry. If it's going to be between me and my client, then yeah. But for the most part, I was always quick-witted, meaning I always thought quickly on my feet. I still do. That's why I'm a strategist now. But I still don't like to be put in that position. And I try to make it very comfortable for clients to tell me anything and everything. I try to make it really easy for them, really comfortable with, I try to have no judgment. I try to, keep the lines of communication open. I even try to share some of my own personal experiences just to make them feel a little bit more comfortable, whatever it takes, because I think that's important. I think it establishes a certain relationship with your lawyer too, when you can be really honest with them about what's going on, whether you think it's important or not, or whether you think it's bad for you, or the lawyer's going to judge you, whatever it is. I think it's important. The client must honor the fee arrangement as agreed to with the lawyer, and to the extent required by law. So that's why it's so important at the beginning, when you're signing the retainer agreement, to understand how the lawyer is going to communicate with you, how you're going to be billed, and whether or not you're going to get copies of all documents. Those three things. Everything is important, but those three things are very, very important because it helps minimize a lot of what I just said people complain about most, right? So in that, you have to know that when you're signing those agreements, you're agreeing to pay whatever it is your lawyer bills you for. So that means that if you are not satisfied with your lawyer, for whatever reason, you can't just decide to not pay him for work that was already done. And if you do that, technically you're supposed to follow that provision in the agreement and either proceed to arbitration, mediation, whatever it is. But it's you're breaching the contract when you say, I'm not going to pay you because I don't like the way you handled blah blah blah. Although, despite the fact that they did the work, you just don't like the way they did the work. If that's the case, that's a fee dispute. You have to handle it as a fee dispute. When you get the client's rights and responsibilities and you sign, because you have to sign receipt that you received your client's rights and responsibilities, you're binding yourself to paying the lawyer for the work the services that were already rendered, right? So you can't, it's not fair for you to not pay them for work that they've done. If it's unsatisfactory, there are avenues for that, okay? Because now, if you do that, and the lawyer has to bring that up, not only to court, but any potential lawyer you try to hire now, they're going to be wary of that. They're going to be like, oh, you're a non-paying client. I don't know if I want to be bothered with a non-paying client. I mean, there's some lawyers who are going to take your case no matter what, because lawyers are just like anybody else. They have to eat. They have to live too. So there may be some who needs your case, who needs the money that you have. But, for the most part, lawyers who know that you are a non-paying client, or you're a client who complains about everything, that to them is unjustified, and your way of dealing with that is to just not pay instead of going down the proper channels, you're creating a reputation for yourself. Not to mention with the judge. Not to mention if the lawyer goes to court and tells the judge that you are not paying for services rendered, the judge is going to not look at you favorably, I'm telling you. And they may not say that openly, but trust me, they do, because they're going to assume that you signed the retainer, and you got the copy of the statement of client's responsibilities. And they're going to assume that you agreed to follow the responsibilities, and now you're not. A client who discharges the attorney and terminates the attorney-client relationship must nevertheless honor the financial commitments under the agreed arrangement, which is basically what I just said. If you have a problem, there's usually a provision in your retainer agreement that actually spells out the route you're supposed to take if you have a problem with your lawyer. Okay. In addition to filing formal grievances or formal complaints with the ethics committee. If there's a dispute over money, of you paying the money or them overbilling you, there's usually a provision in your retainer agreement that covers that. The answer is not to just withhold the money and say, I'm just not going to pay you. You're supposed to go through the route that's spelled out in your agreement. That's your responsibility. Although the client should expect that his or her letters, phone calls, emails, faxes, and other communication to the lawyer will be answered within a reasonable time, the client should recognize that the lawyer has other clients who may be equally deserving of the lawyer's time and attention. That's a tricky one, because as a client, you do expect to, right, wrong, or indifferent, as a client, when you're in that position as a client in a custody battle or divorce or whatever it is in family law, you will expect that everything is an emergency, right? Everything is of urgency. It deserves the lawyer's prompt attention. It's a priority, and I get it. We all get it. But say if your lawyer has 20 clients who all think that way at the same exact moment, how do we prioritize? And we're human, How is your lawyer supposed to prioritize who should get the attention first? And so sometimes it's not intentional that they don't respond to you, as quickly as you'd like. It's just a matter of logistics or practicality, So the term reasonable, within a reasonable time, that gives a lot of lawyers a little leeway, a little wiggle room, right? Because the reality is, what's reasonable to you may not be reasonable to me, because you're just one client, and I know your life right now is chaotic. But if I have 20 clients whose lives are all chaotic, right, on top of the fact that I have my own life, what you may think is reasonable may not be what I think is reasonable. Now, if I have 20 clients who have emergency situations, and you're one of them, and you think your urgent situation requires a 24-hour turnaround time for me to respond, and I don't, because I think your emergency, it may very well be an emergency, but it's not at the top of the list an emergency. So the one who's at the top of the list, they may get a response within 24 hours. And the trick is, if you file a complaint based on that, unfortunately, because of the way that's written, we get to determine what's reasonable, right? And a judge or an arbitrator or a mediator who's going to hear the case is going to defer to us or the lawyer in your case, because reasonable is subjective, right? It's subjective from where we stand, not where you stand. It's from where we stand. So, and I don't condone lawyers who completely ignore clients. I just don't like that, because what I've learned when I've done that is it creates more angst. It creates more anxiety. It creates more dissension between me and my client. So even though they may be on the list of 20 priorities, even though they may be 19 or 20, I'd like to communicate with them to let them know that I'm not ignoring you. I got your message or your messages. I will respond to you. I will get to you as soon as I have a free moment, period. And that most of the time that assuages them. Some lawyers want to say, I'll get to you within the next 48 hours, whatever. I'm going to say, I'll get to you as soon as I have the first free moment. And that's reasonable. And, you have the responsibility to accept that that is the way it goes. Yeah, you can still file a complaint. You can still, complain or, bitch and moan about it. You can still do all of those things. But what matters is if you file a complaint and, as I said, we have an explanation as to why reasonable is what it is for us as opposed to you, right? We're going to get more deference because it's subjective, The client should maintain contact with the lawyer, promptly notify the lawyer of any change in phone numbers, addresses, blah, blah, blah. That's a no-brainer. The client, I wanted to get to the client must realize that the lawyer is required to respect only legitimate objectives of the client, and that the lawyer will not advocate or propose positions that are unprofessional or contrary to law or the rules of ethics. And that one is really, really important, because not that I've run into that a lot, but I do see it enough now where some clients expect their lawyer to do whatever they say just because they're paying them, and because they pay them promptly or they pay them handsomely or blah, blah, blah. And that's not how it works. And I'm not talking about blatant unethical stuff. I'm talking about some things that they want their lawyer to do that is completely antithetical to the objective of the representation of the case. And I'm starting to see that more and more now, and it's a little troubling, because it's like you work for me mentality, so you do what I say, and that's not the relationship. That's not the dichotomy that's created when you're working with a lawyer. It doesn't work that way, right? And that's I think I mentioned last week, that's a huge reason why lawyers actually fire clients. That's one of the main reasons why lawyers fire clients, or that's one of the main reasons they use to, or explanations why they use to ask the judge for the permission to withdraw from a case, because either that, or they're uncooperative, or they are they can't be reached. So the client must realize, no, I think I read that. The client may decline to accept the matter if the lawyer has previous personal or professional commitments that will prohibit the lawyer from devoting adequate time to representing the client competently and diligently. Yes. And actually, the lawyer should decline. I don't see that too often. If I decline a case, if I did in the past decline a case, I'm trying to think if it was for most of the time when I declined a case, it was usually because it was out of my field of expertise, or the time commitment maybe wasn't conducive to my current caseload, or honestly, if I anticipated a client being almost impossible to work with, I would not take their case. And I could get that sense almost immediately. Just from, a client who comes to me and has already worked with 4 or 5 different lawyers, no, I'm not touching that. And most lawyers won't. A client who comes to me and refuses to accept responsibility for, most of the things that happened that brought them to the point where they are, no. A client who is always trying to negotiate my fees, no. A client who comes to me with a very, very convoluted case and they only have a certain amount of money, no. So the bottom line is, we have that right. We can refuse to take on a client, and we should refuse to take on a client if we know the time commitment is something we can't accommodate. A lawyer is under no obligation to accept the client if the lawyer determines that the case or the client is without merit, a conflict of interest exists, or the suitable working relationship with the client is likely. That's what I just said. Those are the things I just mentioned. So I'm going to leave it at that. I don't have any questions or comments. Again, not everybody is going to choose to work with a lawyer for whatever reason. And I understand that. So you may think that these last few weeks doesn't pertain to you, but it should still. Because at some point you might want to, you may be offered free services. You may want to consider hiring a lawyer for a part of your case or somewhere down the line. And so you should know ahead of time what you're legally entitled to as far as, the working relationship with the lawyer. So anyway, that is it for the day. I am Tracy B., the divorce solutionist, a family court strategist and coach. I'm a former family law attorney, guardian ad litem, and mediator. I offer consultation. I offer consulting and coaching services. I offer unbundled services, which is document review, document preparation, case law research, judge lookup, background searches, financial asset searches, process serving, and uncontested divorces. That's part of my unbundled packages, which is like I was just mentioning earlier, where it's like a limited service that I provide. So you can reach me at on Facebook on my business page, which is The Divorce Solutionist, or my Instagram, which is The Divorce Solutionist. Twitter is The Divorce Solutionist. LinkedIn is The Divorce Solutionist. My website is www.thedivorcesolutionist.com. My email is divorcecoachesq@gmail. You could also DM me on Facebook. I have a couple of groups on Facebook, the Divorce Glow Up and Pro Se Divorce and Coach. In custody, sorry. I'm working on my first book, my first ebook, which should be hopefully be out this fall. But I'm hoping to release the first chapter free really soon. I'm working on some courses. I'm working on a couple of workshops. So sign up for my newsletter, my weekly email newsletter that I send out. Sign up for it on my website, and you will stay apprised of everything that I'm doing, even discounts and the freebies. I give out tons of freebies. So anyway, until next Thursday, I'll see you then.